Welcome to Sovereign Citizen Legal Encounters. All right, today we're going right into Judge Slavin Court for Eric Martin. The famous Eric Martin finally gets to start his trial up. Now, I know I might be a little behind on this video, but I've been putting out other episodes and I just didn't get to this one. But for those of you who may not have seen it, it's here now. And then it's going to be in 3 parts. So this is part 1. And I will have a surprise for y'all on one of the parts. I'm not going to tell you yet, but it's going to be really, really good. I promise you. Okay, let's get into the hearing.
Your Honor, David, on behalf of the City of Taylor.
All right. And for the defense?
Good morning, Your Honor. Attorney Josh Hadley. I appointed counsel on behalf of the defendant, Mr. Eric Martin. Briefly, Your Honor, I'd like to make a record. We were before this court last week, and there was a motion, a pro se motion filed by Mr. Martin to have me replaced as counsel. I was never served a copy of that. Your court graciously did send a copy. I have had a chance to review it. Your Honor, I would just again state that if Mr. Martin and I have a fundamental disagreement as to trial strategy, pursuant to People v. Charles O. Williams, 386 Mich. 565, 1972, good cause exists for a substitution of counsel. If there's a difference of opinion between the defendant and the appointed counsel with regard to a fundamental trial tactic, as well as going to People v. Bass, 88 Mich. 793, 1979, good cause can also be found. There's obstruction of communication and breakdown. Now, my recollection, Your Honor, last time I denying the motion was really how late in the game the motion was. It was going to be prejudicial, essentially, and disruptive of the judicial process.
That's correct.
If I recall correctly, one of the other concerns we addressed was the concept of Mr. Martin's belief, which I think we've now clarified, that I'm not restricting him from speaking in any way, shape, or form today.
Nope.
Very well. Your Honor, I would also like, I believe, again, I don't want to put words into this court's mouth. My understanding is my role today, as if Mr. Martin wants to advance the defense that he has selected, I'm here to aid him with the understanding of the Michigan court rules, the Michigan rules of evidence, and all federal and state applicable law.
That's correct.
Very good, Your Honor. Okay, because of that, again, I think I just, for Mr. Martin and myself and this court and the people to be on the same page, for these reasons, I will not be making an opening statement, or I will reserve an opportunity for a closing argument.
And I will say this, I'm going to go ahead and give the ground rules to Mr. Martin so that he understands. Mr. Martin, you are lead counsel. You are your own lead counsel, and you choose to be representing yourself. Is that correct?
Present myself, not represent. I am myself, but
Listen,
I'm not presenting myself.
I'm going to tell you this right now. I'm going to say it one time. I'm not going to sit here and split hairs on meanings of words. To represent oneself or present oneself means the same thing. You are speaking on your own behalf. Yes?
Right, yeah.
Great, very good. Both of them mean the same thing. So we're not going to play semantics because literally I'm a walking thesaurus. So I'm not going to do that. And I'm going to shut that down because you're just going to waste time. I'm not here to stall and waste time. I'm here to make sure your due process and you have a fair trial. And as part of that fair trial, you're not going to try to disrupt the proceedings by either stalling, playing semantics with, well, it's present instead of represent. It literally has present in it. Represent just means to redo it again. That's all. And so every time you get up, you're just representing yourself again. You're representing is what it means. That's what
I
represent.
had to make up the semantics.
So anyway, so here's the thing. You're going to be the lead counsel, so you're going to do your opening statement, things like that. You're going to follow the court rules. You're going to follow the same rules of evidence that everybody else follows. Mr. Greco is not going to have any advantage over you. You're not going to have any advantage over him. If you literally have a legal encyclopedia sitting next to you, someone who is very competent in the laws and the court rules and the statutes and the rules of evidence. So if there's an objection or things like that, I will pause. So that if you think that there's an objection and you think that there is something like that, I'm also going to ask you, because you have someone who is so astute at trial practice, if your co-counsel, are you giving your co-counsel permission to say objection when he sees something objectionable that you don't recognize? Because I'm just saying you don't have a Juris Doctorate, you haven't formally studied the rules of evidence in a formalized setting. You could have done so online or anywhere else by library or by book or whatever. I don't know that you have or haven't, but I don't want to presume. But I just want to know for the flow of things, because if someone says something, they're going to keep asking questions unless somebody jumps in with an objection. If you don't recognize the objection, but he does, are you giving him permission to assist you by saying, hey, hold up, that was objectionable?
Yeah, as long as he's going by the law and not doing nothing that's going to violate my rights.
Well, I just want to know, I mean, and I'm making sure that this is your protection. He's there for your protection. I'm asking this question because just from a flow of trial standpoint, somebody who knows what's going on would be, because I do it all the time, sometimes sitting here, like someone will ask a question and I kind of like, I'm watching. And I would have said objection if I was the other side, and they don't object. And I don't even know if they didn't pay attention or they didn't know, or I don't know. But I can't do that for you. I have somebody here who is very astute at that. Are you giving him the power? I know you want to speak for yourself, but this is the one situation where you have to respond like right now. You have to like block, you have to like do something. And if you don't recognize it, I want to make sure that you are giving him permission for him to do that. Is that okay?
I'm going to do it, but I also reserve my right to also make.
No, sure. I mean, and all I'm saying is I'm going to have him call the timeout. I'm going to have him till the timeout flag by saying objection. Then you two of you can talk about why it's an objection and then speak to the court. Because if obviously you didn't see it or recognize it, he did. So there's probably a reason why, because he's not just going to throw out the word objection for every little thing. You're also not going to throw out the word objection for every little thing. Because if you say, I'll give you three. If you came up with 3 frivolous objections in a row because you don't know the court rules, then I'm going to turn the case over to him because he knows how to do it. You understand what I'm saying? I got no problem with you and your closing argument, your opening argument. Sure. If you want to cross-examine a witness, sure. But it better be within the rules. It better be as to the elements. It better be as to the case, not anything in some other tangent about anything else. It has to pertain to relevance. Because every single piece of evidence, I'm just going to give you a quick update on the rules of evidence. The first rule, rule 401, is that all evidence must be relevant. So if it has nothing to do with the elements of driving on a revoked license, I don't want to hear it. If it's anything to do with bias, yes, you can go into bias, because that is one of the things that you can bring up under rule 403. But under rule 403, there's also overly repetitive evidence. So if you're going to ask the same question 20 times, just in 20 different ways, you're going to get an objection, and I'm going to sustain that objection. You understand what I'm saying? Okay, very good. That's all. And I just want to make sure so that, because everybody who's here, who's going to be in a jury, they have a right to serve as jurors. And I'm not going to have them sit here for an extra hour just because you want to play semantics, because now you're violating their rights perhaps by doing that. But I want to make sure that you have full representation. I want to make sure you have full due process. I want to make sure you have access to an attorney. And again, I'm going to ask you, are you knowingly and voluntarily choosing to not take house counsel? You're going to represent yourself as lead counsel?
Again, like I said, before,
just a yes or no. I mean, are you representing yourself as lead counsel or knowingly and voluntarily?
I reserve my right to say what I want to say and help myself in the case, but it's also okay for him to, also want him to do his duty and offer me the effective.
So that's what I'm saying. It's like, I don't want to leave him in a position where he doesn't know exactly what his duty is. He's either lead counsel or he's just a helper who's just going to sit there. Unless you ask him a question, he's not going to do anything. That's what I'm trying to ascertain exactly what it is you want from him. Officer Rose, good morning, sir. I'm well. I'm always well.
Okay, well, first remember, Slavin, you said yourself, you said it was okay, Judge Slavin, you said it was okay that I say what I want to say, and you say it basic. So I don't see what the questions.
But the questions aren't so much for you. The questions are basically because I want to define the parameters of what your co-counsel is going to be required to do. Because I'm not going to have a situation where you're like, well, he didn't say objection on this one time and he could have had an objection and now I'm going to sue him. Because you're asking me to appoint him sort of with one hand tied behind his back. He's either going to be able to do his job to the fullest extent and represent you as a zealous advocate that he is, or he's going to be an encyclopedia of legal knowledge sitting there only waiting for you to take the book off the shelf. I did create that one situation where you could let him carte blanche. If he thinks there's an objection, say objection, which will just basically be a timeout. Then you can group or powwow, whatever you want to call it, about what that objection would be. And then we'll proceed and I'll make my ruling on it. But other than that, he's not gonna jump in, chime in, any of that. Is that what you, because you're running the show on the representation, correct?
Well, yes, but I was gonna say,
There's no.
I don't want to give up my right to effective assistance of counsel.
Right,
He is-
well, that's what I'm saying, you're either gonna accept it or you're waiving it, there's no half waiving it. You understand what I'm saying?
Eric Martin always has to say something. It's never smooth with him. The Judge Slavin's trying to make it as good as he can, and and giving him the rules, and he always has to throw a monkey wrench in it.
I'm just making sure what it is, because I don't mind whichever way you choose.
Based on what he just told me, I should say lead counsel based on, not just because what he told me, but.
So based on, well, first.
But like I said, I'm gonna do this job. I'm gonna say what I'm gonna say.
Hold on, because I don't want you to say, because I don't want to hear whatever private conversation you had between the two of you. Because I know you just said the words based on what he just said. I didn't want you to say whatever, because that's private. No one can make anybody testify what you two talk about. That's privileged. If you say, listen, if you say to the court, or if you say to anybody, anything he said, it removes and washes away all privilege to it. Okay, so I'm just letting you know that, so you understand. So any conversations you have with counsel, even though he's not technically counsel, but he's your assistant counsel, any conversations you have are privileged. So unless you say, well, he just told me this, well, now you just threw it. So I'm just trying to lay these ground rules so that we don't run into this during the trial anytime. So that you understand and agree. And I just want to make sure that you are knowingly and voluntarily choosing to represent yourself, knowing that I would have given you full access to an attorney. You're choosing not to take that access and you want to represent yourself. That's correct?
I'm choosing to present myself, but also I'm not waiving my right to be helped by him because I still have the right to do it. So I was still.
Okay. So if he sees any objections, he can do objections, but other than that, you'll just stop and ask.
And like I said, then
Okay.
we can't, I ain't predicting the
Just
future,
making
so I
sure.
don't know what's gonna happen. You don't, but as long as he don't say something.
Sure.
Violates my rights, if he does, and I'm gonna let that be known, I'm gonna object to him, whatever. doing
Well, see,
whatever.
now we're right back to, all right, so you know what, I'll just play it by ear, and if I think that you're doing anything at all that's contemptuous or just trying to stall on this, then I'll make my rulings at that point. But
I feel very comfortable with the understanding of the speaking objections, just so I'm on the same page. Everything else I will serve in a co-counsel role.
Yep.
Until directed otherwise.
Yep.
Very good, sir. Thank you.
Very good. All right, so now, as to the motion. Doesn't have a motion. Oh, I just. So if they can't hear, I don't know if they can't hear, I don't know. It's not my problem, it's for the public comment, I'm not sure what's going on. Guys.
Possibly. I have a copy of the motion that you filed this morning.
Okay, just want to make sure that.
Yeah.
All right, so. All right, so I see you filed a motion this morning. This motion is a motion and demand to dismiss or discharge this case based on equal protection clause violations. And I have read through your motion. And did you give your co-counsel the opportunity to read the motion? Just in case if he asks you any questions, or if you ask him any questions.
Your Honor, I have had an opportunity to review all of the pro se motions that have been filed in this matter. So yes,
Including the one this morning.
We had a chance to review it together.
Okay.
Yes, sir.
Right, good. Just want to make sure in case you need to assist in that way.
I guess I'll just add, I have nothing to add.
Sure. All right, so this is your motion, Mr. Martin.
Yeah.
And basically it states that you think that there's a conspiracy between the police department, Officer Borg, Mr. Greco, and myself to prosecute you and keep you from getting your moped back. Is that basically?
Not just that, it's not completely, totally current. So, okay, so the prosecutor calls herself supposedly prosecuting me here on this case when I have, sought to prosecute Anthony Borg for stealing my moped, which is larceny, without my consent in violation of Declaration of Independence of 1776, along with my due process rights of the Michigan Federal Constitution. Okay, he had it towed immediately. And like I said, I filed actually state criminal charges myself with this court. They haven't been acted on. Greco here has not made no effort to prosecute it. And basically, like I said, so that violates my equal protection right. You know, if I'm being prosecuted, I have the right to prosecute when crimes being committed against me. But that hasn't been respected in violation of my crime victims' right of the Michigan Constitution, you know, in addition to the due process. So yeah, like I said, so it violates equal protection clause violation, not allowing me to prosecute also for the crimes committed against me. Therefore, the case should be dismissed based on that.
Prosecute?
And Mr. Greco?
Yes, very briefly, Your Honor, I just had an opportunity to look at it, and this motion has no basis in fact, law, or logic. Mr. Martin is being prosecuted validly because he was operating a moped on the road with a revoked license and or no valid license. The moped was taken by area towing at the time because it cannot be on the side of the road and not left in his custody when he is refusing to acknowledge that he is supposed to have a license to operate a moped on the road. There is no basis to charge anyone else criminally or conspiratorially in this matter. So it should be denied.
Judge, can I respond to that?
I'm sure.
Okay, well, first of all, state statutes cannot violate the Constitution. As we know, and the Constitution clearly says that property is not to be deprived before a due process of law, before a hearing. That was, as you just admitted, it was taken by area towed immediately. You know, without before a hearing, without any due process of law. It did violate due process. And you know, and besides that, based on my right to travel, my right to own my private property, I was supposed to take it anyways. So the state, even there's a state statute that seems to allow it, it's an unconstitutional state statute, and that doesn't override the Constitution. Again, the Constitution says private property is not to be deprived.
All right.
So
based on all the testimony that I just heard and reasoning, plus after having read through the motion, I am going to deny your motion. There is no violation of equal protection under Michigan Compiled Law 257.252A, which is the abandoned vehicle statute. Anytime that there's a situation where a vehicle has to be abandoned, obviously the driver of the vehicle was arrested for not having a driver's license. That vehicle can't just sit there on the side of the road, because why? Well, that's the city's job to protect that, and it also becomes evidence of of what was taking place. So that has to be impounded pursuant to the abandoned vehicle statute. Additionally, the due process that you say you are not going to seek, you actually will seek, because it's built into Michigan Compiled Law 257.904B, which states that when a person is convicted of an offense that's punishable by that section, the local ordinance, basically for operating a motor vehicle while their license is either suspended, revoked, or denied, the court shall order that the motor vehicle, if it is owned in whole or in part by that person, and the court shall order that the vehicle be impounded for not less than a period that the court orders, but not more than 120 days from the date of judgment. But what happens in the meantime and in between time is an actual trial that we're about to have right now. So that is the due process that the Constitution affords, because if it's found not guilty, then your moped gets put back to you. There is no cost assessed to you. The city will pay any cost for impoundment and fees. Why? Because you're found not guilty.
See, Eric Martin's supposed to know law, but he didn't know that.
So the fact that you're stating that you're not getting due process, well, we're about to start the due process, which is the trial. So for those reasons, your motion is denied. Now, you can put that in the file. Put that here. Denied for reasons stated on the record. Now, with regard to one other supplemental thing. So the civil infractions that are in here, the no proof of insurance and the defective tires, those both stem from the same incident occurrence?
That's correct, Your Honor.
And are we setting these for a formal hearing? Are we having these as a formal hearing now with regard to these as well?
However the court wants to proceed. I mean, if we have a jury, we've got a jury. I mean, we
Because
could
the
do
jury doesn't do these.
right. I mean,
So
if you want to do
you want, because what I'm saying is, I have no problem if you're going to put in evidence and it's going to be the same witness, and I got everybody here, I will make a ruling on these after and outside of the jury's decision-making and vision. So they're not
Yes.
going to see that, so they won't be influenced in any way by it as to, well, the judge said he's already responsible for those, he's probably guilty. They won't hear anything from that. I'm just saying I'll make that a separate ruling on this, but we're going to have the formal hearing with regard to these, because I think having a trial on this is about as formal as you can get. So, but all of the decisions and everything about these will be outside of the jury's presence, because I don't want to taint the jury to think that, you know, oh, well, the judge said he's guilty of the other things, so he's probably guilty of this. They're not going to hear any of that. Just put it in your evidence and I'll make sure of it afterwards.
Okay, fine. That's what we'll just address it during
Yeah,
the
that's
correction
gonna be
process.
part of
That's fine.
the. And Mr. Martin, with regard to that, you'll be able to cross-examine about anything like, you know, the tires, they won't understand what it has anything to do about anything, because I'm not going to instruct them that they're even thinking about that. I'm the one who'll make the decision on that, because these aren't jury trial things, it's just civil infractions. So, and that way it's not gonna, they're not gonna get into it or about anything or hear anything about it really, other than they're gonna hear the evidence for everything. I need to hear the evidence about this. So if you have any cross-examination with regard to defective tires, if you have any cross-examination with proof of insurance, you know, I don't know, maybe it was on your phone, maybe it was in your pocket, or I don't know. I don't want to put it, I'm just saying, you can ask about all those things and make sure you're doing that, because we are having the formal hearing on these as well. So they won't understand that it has anything to do with their stuff. I'll make that determination after they're gone. So that way it doesn't change their viewpoint of view, okay? So,
We're clear, Your Honor.
okay, very good. So let's go ahead and,
Before we go
any
to-
other supplemental matters?
I think there was one outstanding motion that at our last pretrial hearing, Mr. Martin attempted to address with the court. I believe it was filed. I see a motion with an October 25th date. Is this the same argument?
October 25th.
Your Honor, it's a motion titled, motion for demand to dismiss, discharge these cases based on the attached legal arguments titled nobility. I don't know if the people were served a copy of this pro se motion. I did get a copy from your court staff.
Okay.
Let me converse real briefly with my client to make sure he wants to move forward with this argument. Okay, my apologies, Your Honor. He is ready to move forward with this argument.
All right, so the only other outstanding motion, and then the last time we were here, I said on the day of the trial that we'll clear up any outstanding motions that had not been heard. The only last motion, and obviously you filed a new one this morning that you brought with you, and we heard that, we discussed that. So you have this other motion for demand to dismiss and discharge these cases based on the attached legal arguments of title of nobility. So give me 1 second too, because I don't know if it's. Did you have attachments to that? Because I see you got your handwritten.
So
You got your hand, what I was saying, I have your loose leaf handwritten motion like I see on your normal motions. But then I see like some pages that are, I don't know, it says page 49 of 88. So there's not 88 pages to your motion. is
That was
there?
in the mayor should have crossed some page. That would have been a little more professional, I guess, but you know, let's.
No, I'm not-
Yeah,
I'm
I'll
not-
tell you how many pages there should be here.
I'm not speaking to your professionalism. I just want to make sure that I'm not missing the other 88 pages, that's all.
Yeah, that's on the page now. 5, 6, 7, 8. I'm counting 8 here. 8 in addition to the motion of the actual legal argument. You know what I mean? That's what
Okay, so I got 4 pages of, I got 4 photocopied pages and then 2 handwritten. So 6.
Motion to dismiss.
6, you have 6 total pages.
6 total pages.
Well, hold on, I think you should have 8. Let me see.
One of the pages that's in our possession is a blank page that's looks to be a photocopy of a hand, just loosely notebook.
Let
paper.
the record reflect. I'll just go through what the court has. You tell me if I'm missing something, okay? So I have dated October 25th. It seems to be your title page. Where it says regarding City of Taylor versus Eric Martin, and it says sincerely Eric Martin in red. This is your opening first page. And then I have the motion heading page based on the attached law that is in demand. It is demanded that to take judicial notice of, okay? And so that's the 2 front pages. Then I have
8 pages of a legal argument. I just 8 more pages on each there.
So there's 2 handwritten. And then there's 1, 2, so I have page 49 of 88, page 51 of 88.
That should cross out maybe, you know, maybe
Page
more
53 of 88.
number of the pages.
I know, well, that way, I mean, they're numbered, but I just want to make sure these are the numbers that I'm supposed to have. 49 of 88, 51 of 88,
Wait, where's 50? 40,
53 of 88, and 55 of 88.
Oh,
Those
you
are the
went
ones
from
I have.
49 to 51, this is skipping the page.
Well, that's, I
49,
don't know, I
50
didn't
up to-
file it, I didn't give it to myself. That's
Right,
all I
so you
have.
should have 49, hold on, let me look at it, let me see.
So
You have
should we-
49, 50, 51, 52.
I have a working theory on this, Your Honor.
I don't have 50.
pages. I have pages that have the court stamp every other page. My suspicion is this was double-sided. Did you write that? Were these printed double-sided?
No, I didn't send them double-sided, so.
May I approach the judge with this?
Sure, if you could just take page 50, because I don't have 50, I don't have 52.
Your Honor, let the record reflect I'm approaching with the entire motion. Mr. Greco. you can go.
Judge, just looking from here, it looks like yours are double-sided.
Oh. Yeah, see, mine are double sided.
Yeah.
Okay, hang on a second now.
Okay,
Yeah.
so that's what
All
I'm trying to
right.
get us into it. Here's your motion.
All right, so yeah, I got 50 on the back. So I guess you did print it double sided or something or.
Sorry for the interruption. It just sort of looked like that's what
a
happened.
good call, good pickup, but the record reflected that also violates the Michigan court rules with regard to pleadings, but in an improper state, I'll go ahead and take it in the light most favorable to the improper defendant. So. All right, so Mr. Greco, do you have a copy of this motion?
I do.
Okay, you do. All right, so, Mr. Martin, go ahead with your motion.
Yeah, so with this motion, some of basically what's already said in here is, the driver's license. Okay, the U.S. Constitution started with Article 1, Section 10, the states prohibited from granting titles of nobility. The driver's license is a title of nobility, it's a special privileges for so-called drivers, and it's prohibited.
Okay, so do drivers get the nomenclature of king, duke, duchess, governor, but what specific nobility titles are given to people who are drivers?
As it says in here, like I put in here, it's a privilege granted to a certain, right here, a title of nobility is defined as to nominate to an order of persons to whom privileges are granted. Objection to a title of nobility arises from the special privileges that attach to the title rather than to the title itself. Words and phrases, volume 8A, page 40, a driver's license is a privilege which is granted by the state as a corporation.
Sir, I am going to ask that you not mumble. You're going to speak up because it's hard to hear. I can barely hear you, and I know that Ms. Hancock is going to have a hard time trying to make a record of this.
Yep, this, the title of nobility is defined as to nominate to an order of persons to whom privileges are granted. Objection to a title of nobility arises from the special privileges that attach to the title rather than to the title itself. Words and phrases, volume 8A, page 40. A driver's license is a privilege which is granted by the state. Well, there's a lot of arguments here, but basically summing up, like I said, the driver's license title of nobility, it's a special privileges granted to so-called drivers, a certain select group of people, and U.S. Constitution, Article 1, Section 10 prohibits the state from granting titles of nobility.
Mr. Greco?
Yes, very briefly, Your Honor, the argument that he's asserting with regard to this applicability to driver's licenses has no applicability whatsoever. As the court is aware, being a constitutional historian and an American, that the titles of nobility was a big deal at the time of the founding of our country with respect to nobility titles such as that you described as king, duke, things that would be granted to somebody just by either right or granted certain rights by that title that have no application whatsoever to a state issuing a driver's license for those that are able to obtain one in the state. There's no applicability whatsoever.
So I will note that the Oxford Dictionary defines nobility as the quality of being noble in character. That's one. Two, the quality of belonging to the aristocracy. So, like Mr. Greco said, that's like you're a monarchy or whatever your setup is, like in England, that kind of thing, Duke, Duchess, all that good stuff. So, contrary to Roger Miller and the fact that is anybody who's the king of the road, it's not true. There is no nobility that comes along with driver's license. When they use privilege to talk about privilege, that is in opposed to a right. You can either have something that's a right, or you can have something that's a privilege. And a privilege is something that can be regulated for the safety, health, safety, and welfare of all citizens. Like I said, you keep talking about a right to travel, you got a right to travel. You know what? You can walk anywhere you want to. But if you're going to use something that can hurt somebody else, that needs to be regulated, such as a plane. You can't just go and buy your own helicopter and just, you know what, I'm tired of all the traffic jams. I'm just going to fly my helicopter from my house backyard, land it on top of the courthouse, and then I'm going to just, park here. You know what? You can't do that without a pilot's license. Why? Because you could literally kill people, like if you fall out of the sky. So there's a reason cars can kill people. It's no different than why you have to have a permit for certain weapons. We have a right to, and that's sort of the clear right to keep and bear arms. But you still have to have certain weapons. You have to have a permit for those things. And so there's regulations that go along with that for the health, safety, and welfare. And giving a driver's license is because we want to make sure, the state wants to make sure that anybody who's driving has the basic knowledge and understanding of what it takes to drive safely, so that it's going to be for everybody, for everybody's benefit. So with regard to the violation, there's been no deprivation of your constitutional rights, and there's been no violation of the Constitution. And the fact that you need to have a driver's license is something that has been ruled upon by the Michigan Supreme Court, by the United States Supreme Court, and the right to travel does not supersede your ability to need a driver's license. You can travel all you want to. Like I said once before, you can walk yourself all the way from Forrest Gump from here to across the country and all the way back. But you got to do it by walking, maybe even riding a bike or something that doesn't require a license. But for licenses, certain things need licenses. There's a reason for it. And all of those have been hundreds of cases that say, yeah. So for those reasons, your motion is denied. So now let's begin by bringing in the jury.
Can I object to that? I'd like to respond to something that you.
There's nothing to respond to. I've made my motion. I made my ruling on your motion, and your motion is denied. If you want to appeal it, you can appeal it to the circuit court, but that's between, all right, so.
I will be
Right
appealing
now,
actually.
we're getting to the.
All the verses, I'm going to provide notice that the court will be appealing all the issues that's
Duly noted.
diverse and
Duly
deny
noted.
my motions and demands based on.
Just Slavin is really keeping him at a distance and shutting him down quick, because with these trials, they don't have time to play with that kind of stuff.
Duly noted. right, so I have, tech defendant host is gonna sign in real quick, because he has, 3 different, felonies to swear in.
Just gonna step outside for a moment, Ron.
Sure, so I'm gonna give, we're gonna go on recess, probably 10 minutes.
Sounds great, Your Honor.
So, what exactly, where is this hearing officer from?
Michigan.
Livonia, Michigan. So, I'm going to make a ruling in limine that this guy from Livonia, how does he have anything to do with the allegations that happened on the day of you driving your moped without a license?
Because, okay, now.
Was he driving? No. Yes or no?
It's
Yes or no? Was he driving?
He denied me my driver's license. I tried to get it.
Okay, then that's between
Under
you and the
threat
state.
of arrest, I tried to get the
There's
driver's
no,
license.
that's between you and the state. And that has nothing to do with him, and he can't even be called as a witness in this case.
So until he violated my due process. Like, and I ran
That's
him, and he
between
wouldn't-
you and him and the state and any sort of 42 USC 1983 case that you want to go file. You go ahead and take care of that in federal court, but that guy has no relevance of any kind of anything in this case. He wasn't at the scene. He wasn't making you drive. He wasn't there driving. He wasn't riding piggyback with you. There was nothing going on. So this hearing officer from Livonia who denied your driver's license has nothing to do, absolute zero relevance. I am the gatekeeper of evidence. Rule 401 specifically says that 402 says all evidence must be relevant. And if it's not even admissible. I'm going to tell you that right now. Whatever this hearing officer from whatever you did to try to get your license back, restoration in Livonia has nothing to do. He has absolutely zero relevance in this proceeding. So because of that, under the rules of evidence, I can't allow him to even testify because he has nothing to do with anything. So because he doesn't need to testify, there can't be any defense based on him because he has nothing to do with your case and the allegations of you breaking allegedly the law. So your motion to adjourn the matter because you got to go get this guy as a witness is denied.
Let me explain further, and I'll explain how it is.
There's nothing to explain further. I've denied your motion.
Another shutdown.
I'm not going to keep explaining. Once I make a ruling on the motion, that's the end of that. That's the end of the discussion. Counsel, is there anything you'd like to add?
No, Your Honor, advise Mr. Martin, again, once this court's made a ruling, be it on spoken objections or anything moving forward, if there's continued to be banter that he's been advised, it can be held in contempt of court. I appreciate the court giving us some leeway through this. Do we have any other preliminary matters?
His attorney just saved him.
Your Honor,
Yes, I do. I still have other things to say as to my rights, yes. And I have another motion to dismiss based on my rights.
What is your other motion to dismiss?
I move to dismiss because from the Declaration of Independence of 1776, governments derive their just powers from the consent of the government. I never consented to be ticketed. Never consented to these court proceedings. I'm only here by threatened arrest, because if I don't, could be arrested and all that, but it's threatened arrest. So it violates the Declaration of Independence of 1776 and also Article 4, Section 4 of the U.S. Constitution, my right to Republican form of government. This is all the flags right there, the gold fringe flag, that represents a military jurisdiction. I don't consent to a military jurisdiction. You can't hold it against me over my right to a Republican form of government. It violates my right to a Republican form of government by trying to enforce this military jurisdiction over me.
Are you serious?
These statutes, which what it is, and my right to Republican form of government means my right to common law, and I demand my rights under common law and Constitution, my human rights and God-given rights. And that's been violated so far, but I move to dismiss based on that because the statutes again are it's all under military jurisdiction. Like I said, it violates Article 4, Section 4 of the Republican form of government, which means no statutes.
All right. So you made a, Mr. Greco, do you have any response?
Yeah, my only response is that the entire argument is inapplicable here, is subject to the laws of the state of Michigan and the United States of America, and is subject to this prosecution validly in this courtroom, which has jurisdiction.
I object to that. There's no evidence to support that. Yeah, well,
your
let me ask
motion.
him. I'll ask him.
Your motion is denied for the following reasons. You argue that basically this court lacks jurisdiction over you. And that's just not true. The question of whether a court has personal jurisdiction over a party is a question of law. And the plaintiff, which is here the prosecution, would bear the burden of just showing a prima facie showing that there's jurisdiction. And that's part of the elements. One of the elements is that all these allegations happened in the city of Taylor. And now, under Michigan Compiled Law 600.701, any individuals, it talks about individuals and it talks about general jurisdiction of the court. And it says basically that the existence of any following, the existence of any following relationships between an individual and the state shall constitute a sufficient basis of jurisdiction to enable the courts of record of this state to exercise general personal jurisdiction over the individual or his representative, and to enable such courts to render personal judgments against the individual or representative. One, presence in the city at the time that you're served. So as soon as you got the ticket in the city, boom, that was the jurisdiction. Two, domicile in the state and or here in the city. You live in the city of Taylor, so your domicile is here. And the last one that you talked about is consent, and you said that you didn't give consent to, et cetera, et cetera. So in the present case, you are physically within the boundaries of the city of Taylor at the time of the alleged criminal activity. And because you afforded yourself the context and then that's as minimal context as you need for this court to establish jurisdiction. So for those reasons, and for the reasons stated on the record by Mr. Greco, your motion is denied. So now let's start with the voir dire.
If I get a chance to respond, I want to say something.
There's nothing to respond to. I just ruled on your motion. You came up with this motion last minute and you brought it up. I've thought about it and made a ruling based on the law. And if you think that I'm incorrect in that, you can file an appeal.
Yes, and I'm going to, and I request now that these proceedings be stayed because I want to be appealing these denials. You denied all my motions in violation of the Constitution. So I'm moving for a stay of proceedings until the appeal is decided on this issue.
Motion denied.
Another one.
There's no need to. That's not how it works.
Let it go, Eric Martin. Let it
So-
go.
When the person's appealing an issue, that's how it's supposed to be.
All right, so we're gonna go off the record for a moment. All right, so
I have another motion made to dismiss.
say again, I'm sorry,
There's a motion to dismiss.
and go ahead.
Based on the misconduct of police officer Anthony Borg. This was Anthony Borg before, wasn't it? I had a chance to look at his name tag. But anyway, is this Anthony Borg?
I'm not here to identify people or answer questions. I'm here to make rulings of fact and law, so.
Anyways, well, the police officer Anthony Borg that wrote the ticket. Okay, he was acting outside of his authority as a criminal law enforcement officer and acting as a civil revenue officer because the purpose of the ticket was to help make the city of Taylor richer by trying to impose fines, etc. And yeah, I'll move to dismiss on that. So that he was acting outside of his authority, it's misconduct on his part. So it should be dismissed based on that.
Mr. Greco.
Yeah, brief response. He was not acting outside of his authority. He's a police officer sworn by the state of Michigan in the city of Taylor, witnessed somebody committing a crime and issued a citation based upon that crime with this defendant committing that crime. That's why we are here. That's why we are alleging it. That's why we are pursuing the matter.
Additionally, I am,
Listen, I'm
go
gonna
ahead.
say that, I want to catch up. So
So-
respond to him, can I respond to him? I want to respond to him what he said. Okay, now, isn't it true that the city is?
You can make argument, but you're not gonna ask questions of the city attorney. That's not.
What's part of my right to
No, it's not.
evidence to make
No, it's
argument?
not. No, it's not.
But,
This is
okay, well,
not-
anyways, then I can ask the question, then I'm gonna say, I'll make the argument that, that's not true because the tickets, there is a civil thing behind it where, money's involved, so it ain't just like what he said. There is a civil thing, there's truth to what I said. The
Okay,
city
so
can reach
the-
out tickets and it's a civil, it's acting as a civil revenue officer.
So the penalty, the alleged or the potential penalty for violation of this crime is 93 days in jail and or up to $500 in fines. So if you get found guilty, you can just get 93 days in jail and there wouldn't be any money coming to the city. Matter of fact, the city would then incur a debt because they would have to pay, I don't know what it is, $37, $44, whatever it is, for every day that you're incarcerated. So actually, if we go through this whole trial and you get to be found guilty, you can get 93 days in jail and there might not be any civil part of it at all. That's entirely up to me as a sentencing judge. So, and I haven't heard any testimony, I haven't heard anything because we haven't started the trial yet. So your motion is denied because it basically there's no grounds at all. That's his job, is to do police work. And if it's not, if the allegations prove that you're innocent, that's fine. If they don't prove the case beyond a reasonable doubt for all the elements, then that's going to work in your favor as well. But we don't know because we haven't got to the trial part yet. But that is his job. If he thinks that there's reasonable suspicion that there's a crime going on and he sees that there's probable cause that those crimes going on or happening right in front of him, then he is sworn and duty bound to act upon it. Whether or not he's correct or not, well, that's what this whole trial is for today. So your motion is denied. Now let's bring in.
Let me hold contempt, but can I elaborate? I'm gonna elaborate.
No, you can do whatever you want on appeal, but I've made my ruling on the motion. The motion is denied. So let's bring in the jurors. Hi, good morning, everyone. Just go ahead and file in there. Then once it gets to be, comfortable, then just go to the next level and start filing in after that. And right there in the second row, just go ahead and slide in the second row there. And that's it. Yep. Just anywhere, any of the benches there, just find a comfortable spot. All right. Ladies and gentlemen, I'm Judge Slavin, and it's my pleasure and privilege to welcome you to the 23rd District Court of the State of Michigan. I know that jury duty might be a new experience for some of you, and that's fine. Jury duty is one of the most serious duties that members of a free society are asked to perform. Our system of government could not exist without it. So the jury is an important part of this court. The right to a jury is an ancient tradition and part of our heritage. The law states that both a person who is accused of a crime and the prosecution both have a right to a trial, not by one person, but by a jury of 6 impartial individuals. Juries must be free as possible, as humanly possible, of any bias, of any prejudice, of any sympathy for either side. And each side in the trial is entitled to jurors who keep open minds until the time comes to actually decide the case. So first, let me talk about the impartial aspect of being on a jury. A trial begins with jury selection. That's what we're going to start doing right here. And the purpose of this process is to obtain some information about each of you that will help us choose a fair and impartial jury to hear the case. During the jury selection, I will be asking you questions. This is called voir dire. And basically it means sort of French, Latin, that means to seek the truth. Okay, so we're just looking for people who just want to hear facts and come back with what they think the truth is. So the questions are meant to find out if you know anything about the case. We also need to find out if you have any opinions or personal experiences that might influence you or pull you one way or another automatically, type of thing. And all of those things are fine. Those are just life experiences, but we just, want to know if any of that stuff is possible. One or more of these things could cause you to be excused from the case, even though you otherwise might be qualified, to be a juror. Right? Now, the questions might probe deeply into your attitudes, your beliefs, your experiences. They're not meant to be unreasonably prying into your private life. The law requires that we get this information so that we can make sure that we have an impartial jury that can be chosen. Now, if you do not hear or understand a question, please say so. Just say, I'm sorry, I didn't hear what you said. Or can you repeat that? Please, that's not a problem. I want to make sure everybody hears and understands that. If you do understand it, I just ask that you answer all the questions truthfully and completely. Please don't hesitate to speak freely about anything you believe that we should know. Okay. Now, during jury selection, you may be excused from serving on the jury in one of two ways. First, I may excuse you for what's known as cause. That is, I may decide that there's a valid reason why you cannot or just should not serve in this case specifically. Okay. Or one of the lawyers from or one of the parties from one of the sides, those who are doing those kind of things, they might have they might excuse you without giving any reason at all. This is called a preemptory challenge. They can just be like, I just want to thank and excuse this one, and they don't have to give a reason. It's just a feel, whatever. So the law gives each side the right to excuse a certain number of jurors in this way. If you are excused, please do not feel bad. Don't take it personally. It's nothing against you or anything. It's just a process that everybody gets to have under the Constitution. As I explained before, there may simply just be something that causes you to be excused from this particular case alone. All right, now, before we begin that process of doing the voir dire, I'm going to ask that you all take an oath. So if you could all please rise. And if you could, I just ask that you will swear that you're going to answer truthfully, fully, and honestly all the questions that we asked of you about your qualifications to serve as jurors in this case. If you have any religious beliefs against taking an oath, you can just affirm that your answers will be truthful and fully and honestly as possible. So, do each of you solemnly swear or affirm that you will truly, completely, and answer all the questions about your qualifications to serve as jurors in this case? Yes. Is there anybody who's standing who's saying no to that? Just, okay, very good. And let the record reflect that everyone answered in the affirmative. And you may be seated. All right, so I'd like to introduce my court staff. This is Miss Ronnie Hancock. Miss Hancock is my court recorder. She is my legal administrative assistant and my right hand. And so do any of you know Miss Hancock? No? Okay. This is Officer Rose. Officer Rose is one of my court officers here. This is, do any of you know Officer Rose? Recognize him? This is Officer Kemp. He's also one of my court officers here, just to keep everybody safe and whatnot, help move paperwork around, move evidence around. Does anybody know Officer Kemp? No? All right, I'm going to let the counsels and parties introduce themselves.
My name is David Greco. I'm an attorney for the city of Taylor and prosecutor for the city of Taylor. This is Officer Anthony Ford of the city of Taylor Police Department.
Morning, ladies and gentlemen of the respected jury. My name is Josh Abley. I will be serving in co-counsel to the defendant in this matter. Please state your name.
Objectively, so another defendant fraudulent assumed defendant. I'm living, solving, and private. I'm solving people. There's a difference between that. The defendant and the law, and you guys understand that. That's what someone's been doing all with me for 20 years. But it's true. They're remarkable. It's not the same as Eric Mark, the defendant. So what they do, this is the way the system violates people's rights. Take the name and assume, put in all capital letters name. It's a corporation in charge and act as if it's community. But it's not really wrong. Okay, that's declaration of independence is one legal argument that supports that the government only devises just power 20% of the government. Article 4, Section 4 of the U.S. Constitution also makes it clear that the people have a way of because of that also. It's, I realize when you go outside, you guys, you know, this is like, again, it's someone really knows about the law.
All right, Mr. Martin, thank you for
That's
your
corporation.
introduction. Now, all right, now I'm going to read to you this is a criminal matter. And the paper that's used to charge a defendant with a crime is called a complaint. And the charges in this case is that it is alleged that Mr. Eric Joseph Martin drove a vehicle on a license that was revoked. And that allegedly occurred on July 11th, 2023. So the defendant has pled not guilty to this charge. You should clearly understand that the complaint, the information I just gave you, is not evidence. Okay? A complaint is read in every criminal trial so that the defendant and the jury can both hear the charges. So everybody knows what the charges is, like why we're here. Okay? You must not think that it is evidence of guilt, or you can't think that he is automatically guilty because they've been charged. Now, does anybody in the jury pool know Mr. Greco, the attorney? Any of you know Officer Anthony Borg? No. All right. Do any of you know Mr. Eric Martin, the defendant? And do any of you know Attorney Joshua Hadley? No? Okay. All right. So, do any of you know me personally? I don't see. Okay, I thought a couple of you look familiar. Your name, sir?
Frankie Patterson.
That's correct. Let the record reflect that Mr. Frankie Patterson is one of the home run champions of Little League Baseball that I've ever played with from a long time ago. And, you know, that's one of the things being a judge here, being a resident since a baby when I was only 54 years here. And just tell you, this guy, so many people would just walk him intentionally. They're like, I'm not pitching this guy. He's just going to hit a home run. Like literally, I think he hit 76 home runs in one season. It was like he was either a home run or just like a triple or something. Incredible. I'm going to go ahead and allow Mr. Patterson to be dismissed. Like I said, I could go ahead and give you about 100 other stories about Mr. Frankie Patterson. So I don't want anybody to say, oh, Patterson ruled again because he thought the judge. Mr. Patterson, good seeing you, Frankie.
You too, buddy.
Take care.
Thank you. I can just leave then.
Yep, you're good. If you want to go downstairs, I can give you a check for like
The
this.
check is.
Oh, the check's gonna get mailed. Check will be in the mail.
All right, thank
Yeah,
you.
take care.
You too.
And then, ma'am, your name?
Jennifer Patton.
Yep, and Ms. Padnaw. I don't have any stories about you hitting home runs, but I do know you as well. So you are, I'd like to thank and dismiss you. Thank you for coming in today. And your check will be in the mail as well. Everybody's getting a check out. So. I'm going to remove both of them because. All right, now, as to everybody else, anybody know anybody in the room here? Anybody? No, good. All right, so let's move on. Now, this trial should probably take about an hour or so. Ish. It's like I said, it's there's only so many elements to the case, which I'll be instructing you about. So does anybody have any health issues that would then not allow them to sit for, let's just call it 3 hours? All right, sir, in the back, your name?
Jimmy Carroll.
Could you say again? I'm sorry.
Jimmy Carroll.
Carol, oh, Mr. Carroll, all right. And so you have any kind of medical issue where just like sitting in, because what's going to happen is you guys are going to get picked and you're going to fill these chairs here, so.
Hearing loss.
Oh, hearing loss, okay, no, same here, all righty. Do you have, or do you need any hearing assistance? But, because I do have hearing assistance device
No,
here.
it's not.
Huh?
No, I do not.
Okay, so, but sitting for like an extended period of time would cause you physical discomfort and
Not in that manner, no, sir.
Okay, so you're good to, you're good to be on the jury if you got picked?
If I can hear,
Okay, so do you want to test the hearing assistance device that I have? It's a pair of it's a pair of headphones that are amazing. I wish I could take them home because man, I need them. I'm telling you. So Officer Kemp or Officer Rose, if you would give Mr. Carroll the hearing assistance.
Your Honor, if I may briefly, while we're doing that, a brief permission from Mr. Martin to step out the hallway. As we talked about medical reasons, he's indicated he needs to take a very quick break.
Sure.
We don't need to move the jury. He can take off.
I'm just, well, so I'm going to continue to just ask the questions. These are all basic questions. So if you need to go, yeah, go ahead.
That's how I use the back,
Yeah, not a problem.
frequent urination bladder problem too, so it could be.
I'm sorry.
Frequent urination bladder problem, so.
Oh, okay.
It could be.
No problem. Yeah, sure. Go ahead. Yep, go ahead and run out there. I'm gonna. Mr. Carroll, can you hear me better with those?
yes,
Okay, very good. And so I'm gonna let you go ahead and use those. So does that take care of any problems you might have, you think?
I believe so.
Okay, very good. And there was another hand up in the front here. Yes, sir. Your name?
Jesus right here.
All right, Mr. Jesus. All right. And what, would you have a problem having to sit for like an extended period of time?
Anxiety.
What's that?
Anxiety.
I see. Okay. And would that anxiety cause you to, I mean, I guess I don't know what the effect is. I don't suffer from whatever it is you have, so I don't know. Would it be, you get like a panic attack, or you might get a panic attack or something like that? Okay. And is it brought on by being isolated or sitting in one spot for an extended period of time? Because obviously you can't just get up and leave. Like you're like, yeah, gotta go, gotta run out. Okay, all right. So, so I'm gonna go ahead and dismiss you for cause.
And you're on those numbers.
That was number 7,
Thank you, Your Honor.
Jesus and Barrow. Oh, the other ones, by the way, Jessica Patton was 21, Frankie Patterson was 22. All right. Is there anybody else who has any kind of, yes, sir, in the front?
I have a beautiful bowel syndrome.
Okay.
I mean, so I guess as long as we don't take a lunch or should.
Sure. No, I mean, listen, and what's going to happen is we're going to pick the, we're going to take a recess for lunch, because I know you guys have already been here all day, and I know I get hangry as well, and like it's already 12 o'clock, so I'm going to dismiss everybody to go have lunch and then come back, and then we're going to finish everything up. So so with that, if you have anything where I mean, you can just put your arm up and say, hey, you know what, I can hit a pause, timeout, if that's what you needed. Would that cover any issues that may or may not come up? Okay, all right. Well, I appreciate that. All right, anybody else? No? All right, okay. Does anybody have any site issues, or because there's really, I don't know about the evidence, but as far as the evidence goes, it's all pretty much going to be testimony. So as everybody has, like we already took care of the hearing, everybody can hear me okay? I mean, I will speak up. If anybody can't hear any of the things, I mean, just kind of direct your attention probably to either Miss Hancock or myself. Just put your hand up and just tap your ear. It means I can't hear it. I'm going to say, hey, can you get closer to the microphone? Because I want people, because you guys are the ones who are hearing the evidence. I want to make sure that you're hearing it. So if you're not, let me know. All right. Now, moving on, there is a presumption of innocence. Any person who is accused of a crime is presumed innocent. And this means that you have to start with the presumption that the defendant is innocent. Now, this presumption continues throughout the trial, and it entitles the defendant to a verdict of not guilty unless you are satisfied beyond a reasonable doubt that they are guilty. Now, every crime is made up of parts, and those parts are called elements. The prosecution is the one who must prove those elements, each of those elements, beyond a reasonable doubt. Now, the defendant is not required to prove anything. Okay. If you find that the prosecution has not proven every element beyond a reasonable doubt, then you must find the defendant not guilty. Now, what is a reasonable doubt? That kind of boils down to that. A reasonable doubt is a fair and honest doubt that grows out of the evidence or the lack of evidence. It's not merely an imaginary or a possible doubt, but a doubt based on reason and common sense. A reasonable doubt is just that, a doubt that is reasonable, after a careful and considered examination of the facts and circumstances of a case. Now, In this situation, the defendant is representing himself. He also does have counsel here that I've had, I've asked Mr. Hadley to sit in as his co-counsel. And that's so that Mr. Martin, if he has any questions or wants to take a quick timeout and ask like a legal question, he can ask that of Mr. Hadley. But Mr. Martin will basically be the lead counsel, so to speak, on his case. In this case, like I stated, Mr. Martin is representing himself. This fact should not affect your decision in any way. The defendant has the right to represent yourself. You can represent yourself and under the Constitution, and he has chosen to exercise that right. And like I said, Mr. Hadley is here just to assist him if he needs it. All right. Now, so at this point, we're going to go ahead and take a break. We're going to start at 1 o'clock. And so I'm going to dismiss all of you. I'm going to tell you this. Don't talk about the case. I know we haven't really gotten into any of the facts of the case. You kind of just know the complaint version of the things, but don't talk about it with one another. Anything that's already happened, don't talk about with one another. Don't talk about it to any of your wives, your husbands, your friends, neighbors, anybody on the phone, any of the media out there trying to be like, hey, what is the case about? Say, no comment, you know. So I'm going to go ahead and dismiss all of you. You can go ahead to your cars, go get something to eat. You can stay here, relax, chill, do whatever you want, take care of anything on the phone. And then make sure that you're back here ready to go at 1 o'clock. So if that means you have to be, you know, like 10 minutes before pulling in and then come on up, just come on right up to the, right up here to my courtroom and right to wherever you're sitting. If your exact location is different, like it gets, that'll be fine. It won't matter. So, all righty. So I'm going to go ahead and dismiss all of you now. So please rise.
Eric Martin got shut down quite a bit. Judge Slavin's like, nope, denied. He's going to keep trying to fight, but all of this is just for a traffic ticket. It makes no sense. But anyway, thanks for watching. We're going to have the next part to come up soon, and hope you have a good day, evening or night, and I'll see you next time.